Let's move on quickly to the next session that we have, which is our last panel discussion. Last but not the least, and it's a very important one. So the discussion that we have right now is on arbitration, mediation, and conciliation. And for that, may I please invite our moderator, Ms. Meghna Rajadhyaksha, partner, Shardul, Amarchand, Mangaldas and Company. Welcome on stage. A huge round of applause. They're going to give away so much wisdom, time, knowledge, and effort, so they deserve this applause for that. Next on board is Vineet, Bose, General Counsel, Nuvoco Group. Please welcome to the stage Mr. Rajeevan, Nair, Head of Legal Department, L&T Realty. They're all sitting at the back end. Now we get to see your faces. Now you're in the limelight. Okay, next, Kanaiya, Thakker, SVP, Head Legal, Adani Enterprises Limited. Sir, may we have you on stage? Next again, we have Mr. Zameer, Nathani, Senior Vice President and General Counsel, UFO Moviez. So welcome back on stage. It's not. Any idea where he is? Okay, so I think, Meghna, I'll hand over the panel to you, and we look forward to an interesting, intriguing conversation, which, my apologies, I can't help it, the time is short, and we'll need to finish off in another 40 minutes, max to max. And I will give you a bell 10 minutes in advance. Thank you.
Good evening, everybody, and welcome to this panel on alternative dispute. Good evening, everybody, and welcome to this discussion on alternative dispute resolution. We'll try and be brief and cover as many areas as possible. We could have a 3-day conference just on ADR in India. And we'd really love to have the perspectives that our leading in-house counsels have on this. Just to introduce, I'd like to speak about arbitration, which all of us have at some point of time had experiences with. We'd like to cover a little bit on mediation now that there is introduction of statutory mediation in a whole lot of commercial disputes. And then we'd like to have a brief discussion on future prospects for ADR, what works, what doesn't, what should be better. So to kick this off, Mr. Bose, I think we'd like your perspective, particularly generally on ADR, whether you think it works as a mechanism of redressal, given especially your experience with government contracts.
Thanks, Meghna, and my fellow panelist. I'll just like to say, first of all, it becomes very important to appreciate the point that ADR, of course, the system works the way the normal, when it comes to, always we have a perception it's a litigation. But actually it's a dispute resolution where the balance of interest of both the stakeholders has to be taken care of. And when you say as a perception of an ADR, and there is a perception and reality, of course, what exactly the way ADR is being perceived is that it's something where at a very reduced cost, you can get a faster redressal. It's important that redressal should be there. It's not a time-consuming process, of course. And chances of settlement are increased. So it's not that somebody is going to win or somebody is going to lose. It's a chances of a settlement should be there so that the thing should get settled down. And when it comes to the judicial interference should be minimal. And finality of the award. So this is the perception. And of course, party autonomy and all those aspects are there, which are very well there. But when it seems to this perception, and as compared to this perception, what is the reality? Of course, 2015 amendment, 2019 amendment, lot of change has happened, but still there is a long way to go. When I say long way to go, I can say, of course, you are still lot much depend on the enforcement mechanism, lot much depend on the procedural. There is no procedural certainty is not there as far as the fact you have a multiplicity, judicial interference, all those things are there. There are a lot of changes also, I must say, that the scope of public policy, challenge on the public policy has been narrowed down a lot. In fact, I was one of the matters when I was with Vedanta Group. We had one oil and gas matter, and where which at the enforcement stage, reappreciation of evidence, and then when that didn't work, public policy was sought. Of course, it was a government was on the other side, but what I've seen is that the scope has been narrowed a lot. But again, because I had dealt with government arbitrations a lot, I could say that couple of things where always there is a challenge. First of all, you face a roadblock. Is it contracts are there, everything is there. Once you really the dispute comes, first question we have to face is there an arbitrability or not? That's a very ticklish question, because whenever government is there, it's whether it's part of the sovereign function, it's non part of the sovereign. Even if government is there on the other side as a commercial party, that okay, if you move from that stage, then the next stage will come. Is it involves a public policy? Is it there is a kind of a public policy issue is there in relation to that? Is it dealing with a private law or a public law? For once you have signed on a dotted line, once the terms are very well there, why we have to go into that question at that stage? And of course, if you come across that particular point, then another issue is public interest, or the customer for a contracts like oil and gas and mining and all that, custodian of national assets. So I think those concepts, promissory estoppel, legitimate expectation, everything, even though that's once you have a contract, those concepts should not at all come actually. But then all those, you have to meet all those tests. So it becomes quite onerous. That's what I can see, I can say. But of course, things are changing. It's not something I'm trying to be too pessimist. But yes, these are some of the perception versus reality, or specifically from a government.
I thought you raised two particularly pertinent points. One is that an alternative dispute resolution mechanism will offer you a final resolution, which will be difficult to get, especially in commercial disputes from courts. And the other idea is that you might want to sit across with your counterparty, and that in certain circumstances might be more productive than litigating. Mr. Nathani, you also have some experience on government contracts in your various roles across, as well as across the entertainment industry. Something you would like to share with us?
So on my company side of it, I mean, I am the happiest person in the room today, with a government arbitration getting over in 6 months, with a ex-chief justice of court suggested by the government, and he deciding in my favor and giving me an interest for 5 years. I mean, 6 months arbitration getting decided. Even the government company is in shock, because they also did not expect that this should be so over in so less time. The unhappy part of it is that from last 1 year, it's in appeal and execution. So we have filed an execution and the government has filed an appeal. But probably in next 3 months, I expect everything to close. Because we wasted about 3 hearings in the appointment of ASG itself, is the submission what the government made. But probably I think we should come to a closure. I always feel that now the government and the operating part of it has changed. One remarkably most important thing which I found in this arbitration, it's not about government dealing or, how government deals with that. Like he was giving an example, there are two arguments basically government makes normally in the court. One is a loss to the public's exchequer, and number two is public policy, all right? And believe me, this is about a particular movie, so therefore no public policy of government will be affected, okay? But the sea change which I found in the approach of the government in this arbitration, I suggested 3 ex-chief justices of Supreme Court. The government came out with a suggestion of 3 ex-chief justices of courts. I selected one of the chief justice. The additional solicitor general who appeared in the matter finished her argument in about 15 to 20 minutes because there was no water in the case. All right. So I have now seen a change in the approach. The government company would have dealt with at a certain level, saying that we have conducted an internal inquiry, the IS officers conducted themselves an inquiry, etc. You can't be a judge in your own case, etc. Those are the all fundamental issues which came up. But when I saw matter going to the arbitration against the government, the arbitrator recommended by government, the ASG arguing on a particular point, knowing very well that there was no water in the case, and the arbitration award being received within 6 months with an interest for last 5 years while they were holding my huge amount of bank guarantee, really made a difference to my perception on the government arbitration. That's from my experience side.
Thank you. That's actually very heartening to hear. Usually you would hear of government wanting to engage in protracted litigations. Mr. Thakker, some practical experiences from your end, particularly on court intervention and how you have dealt with it in your legal experience.
Well, I'm hearing from a couple of members about the government contract, but 2015 amendment and 2019 perquisition Supreme Court judgments clearly throwing the sole arbitrator is not unilateral to be appointed. Even there is a clause, so that makes your life very easy. That you can challenge or any IS officer, any MD of the government company cannot be appointed as an arbitrator. That's number one. Number two, even that interested party cannot appoint another party also as a disqualified. So there are many judgments which give you very unbiased opportunity to appoint a sole arbitrator as well. But problem is not within government or private. From my experience of around handling 100 arbitration in my portfolio today, we go for arbitration because of quality and speed. And I think 2015 amendment, they got 18 months time maximum, and then another 6 months with the court intervention and all. But practically speaking, I made a cycle. None of my arbitration award Zameer will be lucky enough to have a 6 months completion arbitration, and I would like to consult him offline what he did with that. But otherwise, 5 to 7 year cycle. Let me calculate the days. Arbitration maximum 2 years, then goes for 34. And I'm really wondering today that except Delhi High Court, all other commercial high courts and other high courts are actually traveling into merit. While section 34, we all know that it is not for the appeal, it's only for referral, and a very limited ground intervention is required. The whole base of ADR model is based on unilateral model, which requires principle of minimum intervention by the judges. But today, all the commercial courts, they will travel all merits, entire argument. None of the 34 is finished more than less than 2 years. And then go for 37, and then go for Supreme Court. So the whole purpose of arbitration, timeline wise, I think need to do something. Apart from the timeline arbitration, I think one has to look into a very way of 34 timeline as well now. Time has come that we should start giving deadlines to the high courts and Supreme Courts also, if real objective of ADR has to be achieved in the country. It's not ad hoc arbitration vis-a-vis the institutional arbitration. All the award coming from institutions or ad hoc has to go to 34, 37. That timeline is a real concern, and any business award or any getting award after 7 years loses completely charm of the business. And that's rightly, somebody rightly said that, justice delayed is justice denied. So it's a time to for 34 and 37 as well. Otherwise, ADR objective will be killed. That's my way of looking at it. Having said that, good part is that 2015 amendment, some timeline is fine, but then journey started, we have to achieve that a lot so
far. On the same note, I think not just 34 and 37, section 9 also sometimes becomes a problem.
Yeah.
Mr. Nair, you had some specific thoughts, experiences on section 9 and how it's been affecting your matters.
Zameer, I'm very happy to hear that you got an award in 6 months. I'm very surprised. I would definitely, as Kanaiya said, no, would like to definitely be considered separately. And what Kanaiya said is also that 34, 37. I'm not even going to. मेरा तो arbitration शुरू नहीं हो रहे. ये section 9 का चक्कर में चलते रहे. So first, you all know section 9. I mean, arbitration not starting at all. I have seen the last 25 years many arbitration is not reaching beyond section 9. What happened to the 2015 se pehle, at least it was too difficult. You can start section 9 even before starting the arbitration, even process of the arbitration, even after getting the award also you can move it. At least that changes have, at least some changes they made saying, okay, now, so once the arbitration started, then we cannot go section 9. But even then they're saying, if it is, then the section 17. If section 17 is inefficacious, again you can invoke section 9. So it's, yeh ghumte ja rahe. So, I'll be very happy to hear the kind of miracle happened, this one. So, I would only say from keeping this kind of experience, I learned something. In all my contract, I insist, please, both the party will not invoke section 9. That is, it's happening. Very frankly speaking, yes, both the parties agree. Baba, hum log section invoke nahi karenge. So, in all my contract, my first condition, before starting the contract discussion, just come to the arbitration, section 9 will not be invoked. That's the only way we can come to some solution, which is practically happening nowadays.
And this has worked, your counterparties
yes,
have
at least parties agreeing, no? Okay, they will not invoke section 9. But it's difficult to convince the government contract. They will some contract, usme se full stop comma nahi change kar sakte. There's another I mean difficulties. But in a private contract, parties are agreeing now into okay, will not invoke section 9.
Mr. Nathani, since there is much interest in your experience with this, would you like to discuss some of the strategic decisions in the UK or US that you feel?
So, while we bolster our jurisdiction a lot, and if somebody else asks for opinion, we charge fees, but among fraternity, it's free. I did a comparative study between our jurisdiction and US, UK, Ireland, and Luxembourg. And, I'll give you some hint about it. So, when we had this particular law, which was passed, Arbitration and Conciliation Act, it was based on unicitral model, etc. We are all aware about it. Okay. Now, if you see the judgments which have been passed, the quality of the judgment, the jurisdiction of India only gets hit on the cost and timelines. All right. And the discussion then becomes whether it should be an ad hoc or an institutional arbitration. Institutional arbitration is now rising. When you had a dispute of Future Group, which happened with Amazon, and there was an emergency arbitration award which was passed in 24 hours by Singapore International Arbitration, staying the arrangement between Future Group and Reliance, now institutional arbitration has now caught the focus of it. So the management of the company also says that, all right, if it is costly, we understand, but there's a quick relief which is available, and Delhi High Court also recognizing it makes a huge difference to that particular thing. Okay. So if you see the timelines of what we followed here in India, so we had one of the first judgments of Bhatia International, which paved the way in 2012 for a confusion. So your Arbitration Act is divided into two parts. Part 1, which is to domestic arbitration, and part 2 is your international arbitration. All right. And Bhatia International order went on the contrary, saying that, this is not applicable in a certain situation to international arbitration. That was then cleared by Balco judgment, which says that, there has been a bifurcation which has been done. What part is applicable to domestic arbitration, what part is applicable to international arbitration, and let that particular model stay, otherwise it will be contrary to the unicitral model, and therefore the order was overturned. This is all happening in 2012, etc. We then had a judgment of Enercon India by Supreme Court, where the discussion came up on the seat and venue. All right. So when you just mention venue of an arbitration, it's the place where you want to sit down and have an arbitration. But when you speak about a seat, it's the applicable law, which is the interpretation which came out in the Enercon judgment. All right. Your fourth judgment was about Lal Mahal. Now, Lal Mahal judgment was regarding the public policy interpretation. Every time government would come to the court and argue, saying that, if this is an order which is given against us, it would affect the public policy of India. All right. Now, this Lal Mahal judgment clarified that, when you're coming to the court and speaking about public policy, please come to the court at an appropriate time. All right. This judgment also clarified that there is a section 48 of the Arbitration Act. Don't misuse that for us to review an international arbitration award which has been given against you. All right. See the clarity with which the Indian judgments are coming up. Now, if you see a contrary judgment of United States, there was a company known as ZF Automobiles. Now, in this company, the Supreme Court of United States. So this was a arbitration award which arose out of an agreement which is known as Commercial and Investment Treaty. All right. So there are commercial and investment treaties which happen across countries, and therefore companies also get into those arrangements. All right. Now in ZF Automobile, which is a 2022 case of United States Supreme Court, in this case, the United States Supreme Court says that if there is an arbitral tribunal which does not get a recognition of a nation and it is arising out of a commercial and investment treaty, such arbitration tribunal is not a valid arbitration tribunal. 2022, which means all contracts which are arising out of this commercial and investment treaty would have an arbitration clause, but that arbitral tribunal is not valid. So the quality of judgment of Indian courts we have seen, quality of judgments we are reflecting on US courts. All right. One more case which came up. Now, Indian courts started clarifying. One was the minimum intervention, which started between 2008 and 2012, where even the Supreme Court said, all right, it's a unilateral model. Arbitration has been enacted from an intention that there is a forum which decides the case in an expedited manner. At a High Court and a Supreme Court level, for every small thing, if we start interfering, then this will go nowhere. So minimum intervention was then decided by a Supreme Court strategically, and that's what is also supporting the unilateral model of United Nations, what was adopted by all countries. 2012 onwards, our court started giving judgments, and they were making it better off for arbitration to become more expedited. And they were good quality judgments. There was a judgment by UK court. Now we have seen India and US court. US court saying that any arbitral tribunal which is arising out of your commercial and investment treaty between the country which does not have a recognition of a nation, therefore we will not grant that arbitral tribunal any recognition. In 2020, a UK court where there was a BP Deepwater Horizon, all right. So what had happened is that BP company was involved in Gulf of Mexico. There was an oil spill which happened. So most of the ESG topics which you'll hear this subject, that there was an oil leak which happened in Gulf of Mexico, all right. The name of the company was Halliburton Company. Now this company went ahead and compromised with everyone, saying that, I'll clean up, I'll pay this, and then it went to Chubb Insurance of United States saying that, see, these are the compromises I've done. These are the arbitral awards I've got. And please, therefore, now pay my insurance to me because these are all genuine claims. Chubb Insurance went back to the United Kingdom court and said that there's a problem because this arbitrator has been there in all the arbitration, and therefore there is a question of neutrality. This is what United Kingdom court decided in 2020. All right. So if you see comparison of the judgments which are coming in India, I feel they are more substantive, they are more faster in terms of time. What judgments which are coming from United States and UK are latest judgments, but they are still in the realm which India court had already decided. So I think as a jurisdiction, I rate our country and our judgments much better than the other countries. Of course, in terms of time and cost, this is one of the factors which has been embracing, not only on the arbitration part of it, but also on the execution part of it. If there is an expedite in that particular area, I think we will be a good choice of a jurisdiction. That's a comparative from my side.
Thank you so much. That was an absolute masterclass. We all have experiences, time spent on arbitration. I just also wanted to pick your brains a bit on mediation. it's widely recognized outside India. There's institutional mediation, and it seems to have been taken much more seriously. We now have Section 12A in the Commercial Courts Act, where before you file a commercial suit before any court, there is mandatory mediation. And the Supreme Court has held it's actually mandatory. There's also a loophole that if you have an application for urgency, you can ask for exemption from the mediation. Mr. Nair, have you dealt with issues where you've engaged in a mediation? Is it ever been successful? Do you think it's just hindering a dispute resolution process? Sorry, also as GC of a realty company, you must have experience with the mediation under RERA and MahaRERA. If you could let us know how that has worked for you.
Yeah. So first of all, so before starting with this, the question you asked, let me understand the entire ecosystem. Even the stakeholders are fed up. The tariq, no. So that is why actually the behind. Except one set of professional, I'm not telling that. Otherwise, everybody is fed up with. So they're saying that we know that we are not getting the matter on listed or even listed then tariq per tariq. So now that is why in 2015 the Commercial Courts Act Section 12A inserted. So Section 12A is actually it's a pre-institutional mediation. It's a mandatory. And though the section was inserted in a couple of, almost now I can say 7 years ago, it was not emphasized. The people are not taking the entire system is not taking it very seriously. Until recently, Supreme Court in August, I think precisely on 17th or 18th of August, Justice K.M. Joseph and Justice Harigesh Roy, they said it is a mandatory requirement. Otherwise, please reject the suit at the under order 7 and 211. That is so. The requirement is that now before any commercial suit starting before that, please initiate the mediation. So that is there are a lot of challenges in that, but I have in my experience, I'll come to the MahaRERA and that mediation. That is what actually is happening actually. The mediation happen actually, to be frank, that mediation successful is only a small stake matters, not in the high stake matter. In the high stake matter, it is still at the end, it is back to after 3 months, or because the session saying three months and further extension of 2 months. So I've seen in my experience is a mediation is a big failure. So again, going back to the court, it is not very, very effective. Okay, I would in fact recommend, I would suggest into this kind of Section 12A also to be inserted into an arbitration act also, so that though the arbitrator, they think you go for mediation is not a compulsory today, but in Section 12 with the recent Supreme Court order, I'm sure the way forward, the people will, litigant will take it very seriously and ensure that the mediation is happening before the initiating the litigations or filing the suits or commercial suits. Now come back to the RERA. I don't know how many are in real estate here. Can you just raise who in real estate? Very few. I'm sure though you are not in real estate, are very few, but I'm sure all of you are purchasing a house. How many are purchasing a house here? That's great. So I'm sure that is Tera Mera RERA sab log suna hoga. Okay, so there's an opportunity for all of you to go. So there are already 19,000 odd complaints are already initiated in MahaRERA alone. I'm talking about. If you go to UP, it is, I don't know how many zero to be added also. Especially recent happened about that super tech, etc. But in MahaRERA now from they saying somewhere in January 2018 they passed an order saying now the mediations, though they also for conciliation rather. So any complaints now going to the RERA before even starting the adjudication, first they will ask the police party, can you both are agreeing for the mediations, and RERA is also some kind of pushing to go for the mediation. So my experience I have seen, yes, it's going for the mediation, and last 1.5 years I have seen approximately around the 995 matters are party agreed for going for the mediations, and out of which some 25 already been even successfully passed order. Why RERA saying the RERA, it is not a big stake matter, though, because it is successfully happening in the MahaRERA and other RERA authorities also now I was told that is I was being informed that is other RERA authorities also now going to step into the similar decision of what Maharashtra had taken. Like Karnataka RERA has taken not mediation, not a conciliation, a log adalat they have started. And other even I was told Haryana High Court is also now starting mediation. But yes, your questions precisely, Maharashtra, the mediation is a kind of success. But in the section 12A, in the commercial suit, the pre-institutional mediation, it is not so successful. But I hope the recent high order from Supreme Court will definitely give more emphasis and it will have much better results. Thank you.
Maybe one of the issues that can be thought about is even now the mediators for commercial suits are not practically trained as specialized mediators that many international jurisdictions have. Mr. Bose, would you have thoughts on equipping commercial courts to support ADR, whether mediation or even dealing with arbitrations?
I think, I would rather like to give a very short answer to this query. Of course, commercial courts, it's basically it's not about the courts and all that, the right set of procedural rules, standard set of procedural rules behind the process. That is very important actually. Second, the prioritization. I mean, I don't know how many of you have dealt with, of course, we deal with commercial courts in metros and all that. Good commercial courts are there. But the same is the case in a remote location like Asansol. And if you have to go a very high stakes strategic litigation and you have to file a section 9 or some kind of a sensitive issue, then because the judicial officers over there, they may be dealing in host of issues, right from family matters or even family court matters, or even those what you call very smaller matters and all that. That right kind of an ecosystem to deal with the commercial matters, that right kind of the infrastructure to deal with the matters are not there. So what happens is this mediation ultimately becomes a kind of a checkbox. Okay, file kar diya, dono mein se kisi ko jana hai nahi. It becomes more or less like that. So I still recall let's say the kind of a procedural applications time to time the parties would file. If there are some strict rules to say that when it comes, it's not like just any suit. It's an ADR. So if in ADR, if there is a limit on the number of applications which somebody can file for miscellaneous procedural aspects, and curtail down these things. And second, conflicting judgments or conflicting precedents are avoided. I mean to say, I echo the sentiment of my friend Mr. Nair. We had a case which is going on Section 9, and it's a very strategic matter. And right now the commercial court is looking into the maps, and you won't believe it. They are looking into the maps first to determine whether they have the jurisdiction or not to deal with that, because the other side has said that the police station which is located, this doesn't fall in that circle and all that, and that is going for last 8 to 9 months. Forget about the Section 9 stage coming into picture. So that kind of a thing is that, and at the same time, and this I'm talking about a court in a metro city. So what I'm trying to say is that the courts are ill-equipped with the right resources. The procedural rules. I just given one example. In the English Arbitration Act, there is a section called Section 68 for an institutional arbitration challenging and all that. I actually realized how strong is that section when we really faced a matter, because generally we said that what is serious irregularity. I think so. I can only challenge an arbitration award on merits if there is a serious irregularity, if it is an LCI or an institutional arbitration. And that serious irregularity is so objectively covered that there was, in fact, after taking views from 4 or 5 QCs and so-called best of the best firms, we couldn't found a way out. So that means that the rules, the process, the law or the rules are so stringent that you don't find any way out and you have to follow that thing. So we have to make our law, procedural rules, law substantive. I think my friend Mr. Jamil has also said that this is something which is which the substantive judgments are coming very well written substantive judgments settling the principles, and it will take a year or two more to settle most of the substantive, because I still recall an issue of an arbitrator fee in our case has went up to Supreme Court, so from commercial court and all that stage. So I think it's the only thing is that procedural rules are very important, which has to be equipping the commercial courts, and then commercial matters should be given a priority, and the right level of priority it should come, how important it's for economic development of the country and all that. That has to be, because that has to be realization. I think those aspects can make the things better. That's what I
Thank you. So where we got to is we need better trained personnel, we need better rules, while we do have substantive judgments to support an ADR regime. Mr. Thakker, any thoughts from your end on what should work better, what is already working?
Yeah, it's kind of a glass of water, half empty or half full situation here. As Zameer rightly mentioned, so far, quality parameter is concerned, Indian judiciary system is the best, be it Europe or US, or in fact to some of my experience of Singapore as well. So quality wise, we are best. But we all are talking about timeline, and I just wanted to add on what Vineet is trying to say, that commercial court in the metros are okay, but when you have the commercial court in the remote locations and a town 2-tier cities or 2-3-tier cities, the whole purpose of commercial court is to have commercial mindset in special court. But the person who is hearing you out in commercial court talent, if you don't have the expertise of commercial or arbitrations or any contractual knowledge and is coming from criminal law background, somebody's transferred from that, and then he's hearing my commercial matter. So then I have the only option to just give him a gnan, make him a master of the law, and then see what order he's passing. And sometimes that kind of order also has to be challenged in 37 then by other side. So the whole point is that quality parameter, we are excellent. Timeline is a problem. But having said that, as I mentioned, something is better than nothing. If I have the option to go for a civil court for recovery or my claim, or if I have to go to arbitration, still I would select for the arbitration, because comparatively it is a speedier or better than civil court. Because I remember when I started my job in 1999, the first case which I was handled for me for recovery, small cost court in Mumbai, 1974 petition that recovery suit is pending, and I'm handling 1999. So those time is already completed. We are moving up hard ahead. But yes, if you really want to go for time and speed, and for example, very recently Supreme Court has passed one judgment in just 2021 about 34. No right to modify the order of award. Now this judgment will create a lot of chaos now. Suppose I have the 10 claims in my one award. Out of that, 5 will be upheld, which is very good, and others are not good. So whether 34 court should intervene or not, or he has only one option, either to set aside the entire award or upheld. So modification right should be given to some extent. So rather than let Supreme Court not rule the arbitrations, but I think rules and regulations of arbitration law itself should be substantial. Some guidelines, some rules, regulations like institutions should be there. That will really help timeline and quality parameter for them.
I also wondered if there were thoughts on arbitration funding, which again seems to be a concept that's picking up in other jurisdictions, and whether that might help promote ADR as a method of resolution in the country. Mr. Nathani, any thoughts on that?
So in fact, when this discussion came up, I had a presentation on litigation funding, and I wanted to portray some figures to you on this. We do have a provision under the law of litigation funding, all right? So you have Civil Procedure Code, Order 25-123, which speaks about that there can be a litigation funding which can happen by a third party, all right? The aspects to be kept in mind is conflict of interest, etc., etc. Those are factors which are there. But arbitration funding today is not available. I'll just give you a few numbers which are there part of my presentation. There was an arbitration funding in UK which is about 700 million pounds. Globally, the numbers of arbitration funding is about 10 billion pounds. All right, so these are numbers. There was an interesting case which happened on SR Oilfields versus Northcott. This was a United Kingdom case where the Northcott company entered into a third party funding arrangement because they did not have the fund to fund the arbitration. Where if Northcott is successful against SR, this is of 2016, the funders would be entitled to recover 300% of the funding or 35% of Northcott's recovery, whichever was greater. And when it came to evidence and all that, Northcott said that these funding terms are market standard and normal. So this is not a provision we have today in the Indian law where arbitration funding, litigation funding of course is supported by Civil Procedure Code Order 25 Rule 123. We should have a provision of arbitration funding also in the Arbitration and Conciliation Act. If other countries like UK, where I gave you an example of SR versus Northcott, where the funders were promised 300% or 35% of the recovery what Northcott makes against SR as a funding incentive for arbitration funding, I think India should look at it. There are countries like US, UK, Australia, Germany, France and Netherlands having a similar thing on arbitration funding. Even Hong Kong and Singapore have provisions where they've introduced legislations to permit and regulate arbitration funding in the international arbitration space. So I feel it's time for a country, for our jurisdiction to also incorporate a provision of arbitration funding. There are certain norms and standards like conflict of interest, etc., etc., which should be put into the law so that there is no harmful effect on it. But I think right now is the right time to incorporate this provision of arbitration funding in the Arbitration and Conciliation Act itself. That's on the arbitration funding side of it.
Thank you. Mr. Nair, what would you see as proactive action, suggestions for reform? What would you see as the future of ADRs generally?
Yeah, one I already told you that is from my experience point of view. Already in section 9, I told you to 1, 2. Everybody, I would suggest you to, if possible, suggest to when you're drafting the contract or when you are negotiating the contract, say section 9 will not be invoked because that's the one. So that the timeline. Second, that as far as mediation is the mediation is the I would say the way forward for the a law stake matters. And yes, arbitration is the one I think everybody looking forward to now. A lot of changes happening because after the amendment, everybody is invoking for arbitration. I think the future is that. And the commercial, this recent order from the Supreme Court, I'm sure that is to allay making more emphasizing, make it mandatory and declare it is all the court has to be now ensure. That was the in fact wording from the Supreme Court saying that section 12A is a mandatory requirement for any commercial truth before invoking. So these are the ones I'm saying timeline. I think you already put a bell mark. So we should, that's all from my side.
I think we can take a few quick questions. I think we've been fairly thorough today. We don't particularly have questions. Thank you.
Yeah, it was a
Thank
very
you,
serious and everybody was immersed into it for sure.
Thank you.
Thank you.